Hi, everybody. Thanks so much for joining us this afternoon. Thanks for giving us a few minutes to get the live stream started. My name is Sam Sanders. I'm on the Policy and Government Affairs team here in DC at the Economic Policy Institute. I'm really thrilled to be here today. We have a stacked panel, so um, I'm hoping the conversation today will be informative and inspiring to everyone who's gathered here. We're looking forward to offering some insights for all of you and different perspectives on what the National Labor Relations Board does and what those agency actions actually mean for all of us, for you on the call, workers, union members, and more. Before we begin, I just want to say a couple of quick housekeeping things to get us started. Yes, there will be a recording distributed to all attendees, and the live stream link is also being recorded to EPI's public YouTube channel, so you can access the video after the fact. And we'll also send around follow-up links and resources. We have a lot of great speakers covering a lot of content today, so we'll be holding questions until the end from the audience. If you want to submit a question for the Q&A portion, please open up the Q&A chat window at the bottom of your Zoom and drop in those questions as they occur to you, and myself and the EPI team will keep an eye out and do our best to put those questions forth to the panelists when they have time at the end. Thanks again for being here. I want to now turn it over to Larry Cohen, our first speaker here. Larry was the former elected president of the Communications Workers of America, or CWA, and he is a lifelong advocate for labor rights and collective bargaining. He has a ton of experience in union organizing and major contract negotiations in multiple sectors, and has worked tirelessly to strengthen labor rights and solidarity both in the US and abroad. We're really thankful to you, Larry, for being with us today, and I'll turn it over to you to introduce a conversation with another guest speaker, NLRB General Counsel Abruzzo.
Thanks, Sam, and thanks to EPI for wonderful work on this, and not only to Sam, who is moderating and helped prep us all, but also Celine McNicholas, Margaret Poydock, and Nicole Lewis, among others, and of course, Lynn Reinhardt, who's with us on the panel. Also, thanks to Our Revolution, Jobs with Justice, the AFL-CIO, and CWA for using their list to build awareness and this amazing attendance. Hopefully, the great group of worker and staff organizers, union leaders, policymakers watching will see this not only as one more Zoom, but as an early wake-up call to organize around building on the amazing work of the General Counsel, her staff, the board itself, as we prepare our own work for organizing and bargaining rights legislation in 2025 and beyond, and hopefully a Congress that's ready to act. Jennifer Abruzzo has been the General Counsel of the NLRB for 3 years, has spent more than 25 years at the NLRB, including Deputy General Counsel and Acting General Counsel, until she was proudly fired when Trump became president. She was the Deputy General Counsel to Dick Griffin. Recently, in speaking to Dick, he said Jennifer was the best NLRB General Counsel ever. That should be the only introduction Jennifer needs. Jennifer talks many, many times, often to lawyers, but she is a General Counsel that wakes up literally every day thinking about workers and then goes to work herself. And today is for workers who are organizing and the union supporting them. We're in an interview format conversation, as Sam said. So Jennifer, welcome. And the first question is what you wake up with every day, your view of the National Labor Relations Act, including the preamble. What should it mean for workers and organizing?
Thanks, Larry. I just want to start by saying it's really nice to be here. And I really, truly thank all the organizations and organizers and activists on the ground for all you're doing to educate and empower and advocate for workers. And I thank all the workers on the call for their interests and their contributions to all of us around the country. So you asked about my views about the act, and what I'll say is, you know, the National Labor Relations Act itself says that it's the policy of the United States to encourage the practice and procedure of collective bargaining and to protect the exercise of workers of full freedom of association and self-organization and designation of representatives of their own free choosing for the purpose of negotiating their terms and conditions of employment. And the Supreme Court, back in 1937, when it found our agency constitutional, also said that the theory of the act is that there's free opportunity for negotiation with representatives of employees. And that free opportunity is likely to promote industrial peace. And so our agency has been, the NLRB has been governing labor relations at workplaces for almost 90 years. We enforce a pro-worker statute that attempts to equalize the bargaining, the power dynamic, in essence, level the playing field between employees and their employers. And in fact, when Congress enacted the statute back during the Great Depression in 1935, it was with the goal of reducing industrial unrest, economic instability that was caused because workers lacked channels to improve their lot in life. So I take my constitutional oath, our congressional mandate to enforce a statute that promotes collective bargaining and the free association of workers to take collective action to improve their working conditions extremely seriously.
Well, we all thank you for that approach. So, as you well know, I learned this from you, actually. From 1949 to 69, Joyce Silk was a key frame for the act and its enforcement. Very soon after you were confirmed, almost 3 years ago, in a memo to the staff of the whole NLRB, you stated that Joyce Silk should remain important as a framework. And in August last year, in a case called Cemex, the board reviewed the consequences of employer unfair practices in a case where there was a demonstrated majority for union support, a demonstrated majority supporting the union. So for workers and organizers listening today, what would you want them to understand about Cemex going forward?
Right, this is really important. And you know, we don't have time to get into all of our statutory remedies, but I do want to talk about the meaningful remedies when there's interference with workers exercising their right to organize and freely choose representatives to negotiate on their behalf, particularly in the fragile time when workers are first organizing a union and then requesting that an employer voluntarily recognize the union as the workers' collective bargaining representative. So, you know, you mentioned that I had asked the board to return to the Joyce Silk doctrine. That would have required recognition of a union unless an employer demonstrated good faith doubt that the union enjoyed majority support from the workers. And I really felt that a return to Joyce Silk would disincentivize employers from abusing the agency's processes and committing unfair labor practices to circumvent the right of employees to freely and fairly choose whether or not they wanted a union to represent them. But the board did not reinstate Joyce Silk as I had sought. They did, as you correctly note. They issued a decision in Cemex. The Cemex decision allows an employer to do one of three things when they're faced with a request for voluntary recognition. So an employer can voluntarily recognize a union who enjoys majority support. It can file what's known as an RM petition, and that could lead to the agency conducting an election in an appropriate unit, or it could do nothing. So those are the employer's three choices. If the employer voluntarily recognizes the union, the next step is bargain in good faith. However, if the employer files an RM petition to either test the union's majority support and or the appropriateness of the unit, or if the union files an RC petition, which it can do, or both are filed, we will process those petitions. But the big key here is if the employer commits unfair labor practices that would, during the course of during the critical period, the the period within which we are processing a petition or after a request for recognition is made. If an employer commits unfair labor practices that would typically set aside an agency conducted election, the board, the CEMEX board has said they're not going to order a rerun election, but rather they'll issue a bargaining order. And if the employer doesn't voluntarily recognize the union or file an RM petition within a reasonable amount of time, which is typically 2 weeks from the date of the request for recognition, and if there's no RC petition, so if there's no representation case that we are processing, then the union can file an unfair labor practice charge, or they can file it simultaneously with an RC petition if it's filed, alleging a violation of Section 8A5 for the failure to recognize and bargain in good faith with the employee's designated representative. So the time period within which what I say the Section 10B period, but the 6-month time period for filing a ULP charge begins 15 days or so after the union has made their demand for recognition, because that's, an employer would have to take action within 2 weeks after a demand for recognition has been made. So if the employer doesn't file an RM petition, the union doesn't file an RC petition, the union files an 8A5 charge saying that the employer has unlawfully failed and refused to bargain in good faith. So that's like the basics, but I do want to I've gotten so many questions from labor side and management side after the CEMEX decision issued, because it's very dense, it's very long for those of you that have read it. And so I issued a guidance memo, and it's GC 2401. So GC 2401. It can be found on our public website. I really encourage the audience to read it, but I will give you a few pragmatic takeaways from it. So as to demands for recognition, they can be verbal or written, but they should clearly state to the employer's representative, agent, manager, supervisor, whomever, the unit that the union is claiming that it enjoys majority support in. And a demand can, take many forms, as I said, verbal or written. It can also be the filing of an RC petition. So you can make a demand through the filing of an RC petition if the union checks the request for recognition box on line 7A of our petition form. And then it may note in that same section that the petition itself serves as its demand. If the union decides to file the RC as the RC petition as the demand itself, or it decides to file an RC petition in addition to a verbal demand or some other sort of written demand for recognition, that filing of the RC petition doesn't waive the union's right to timely file a charge with us, alleging that there's been an unlawful refusal to recognize and bargain. Okay. But if the union does file the RC petition because they want to be certified and then withdraws that petition, and that petition served as the only demand for recognition, but it's still, the union still wants to be recognized as the unit employee's representative, the union should communicate to the employer that despite the fact that it withdrew that RC petition that served as its demand, it still continues to demand recognition. If it does that, then the employer is on notice, and then if it so chooses, it can, within 2 weeks of that withdrawal of the RC petition, file its own RM petition, and then we'll process it. Okay. When it comes to evidence of majority support, an employer may ask to view the evidence, but the union isn't obligated to show it directly to the employer. Oftentimes, there's a neutral third party that may be engaged, like FMCS, for example, that could be engaged to review that evidence. Whatever third party is checking those cards, for example, or whatever evidence there is to show majority support, that doesn't toll the period for the employer to file an RM petition. And we would rely upon the evidence of majority support, like valid authorization cards that clearly state their nature and purpose, if the employer's unfair labor practices invalidated the election process such that an uncoerced choice of employees cannot be reflected through the election process. We will look at evidence of majority support through cards, for example. Then, as to unfair labor practices, unlawful activity that's related to refusals to recognize and bargain may be based on one or more violations of sections 8A1, interference, restraint, coercion, or 8A3, discriminating against union activists, discharging them, engaging in other sort of retaliatory, discriminating conduct. But the one thing that I do want to mention, because the board issued a subsequent decision to CEMEX, Spike Enterprises, in order to pursue a CEMEX bargaining order, unions have to also file an 8A5 charge alleging a refusal to recognize and bargain. So keep that in mind. And then in considering what sort of conduct may be disruptive to our election processes that may warrant a CEMEX bargaining order, the board's going to consider the number of violations, severity, extent of the dissemination, the size of the unit, the closeness of the election, the proximity of the misconduct to the election date, the number of unit employees affected, and the critical period begins on the date of the demand for recognition, and any bargaining obligation attaches from that date. And the one final thing I'll just say is, along with unfair labor practice charges alleging unlawful conduct, filing objections in the related representation case, if there is one, remains a best practice.
Okay. Let me just add that there is also a one-pager on the NLRB website that explains CEMEX. It's
Yes,
almost like a leaflet. And there also is a video that's very good that explains CEMEX on the NLRB website. Okay, final question. What other parts of the National Labor Relations Act might change or might be amended by Congress so that CEMEX could be fully effective?
Okay, well, I will say whether amended by Congress or through further board action. There's a couple of, we don't have, I wish we had more time, but I will just say there's a few things that I personally think would make CEMEX more fully effective. One is, we all know with knowledge comes power. So education about our statute is key. And we unfortunately see employers banking on the lack of knowledge that workers have about their statutory rights, and employers engage in unfair labor practices in order to nip in the bud organizing efforts. They do that, by firing or disciplining, threatening, interrogating, coercing workers. Because they want to squelch the organizing drive and prevent employee free choice. And as many on the call know, or the webinar, often the threats or other coercive statements occur during mandatory captive audience meetings, which I personally think are unlawful because economically dependent workers are not afforded the opportunity to exercise their statutory right to refrain from listening to their employer's anti-union rhetoric without an implied threat of reprisal for refusing to go to the meeting or for leaving the meeting if they don't like what they're hearing. That doesn't mean that I think that employers can't talk with their employees about their views about unionization, but I think the meeting should be voluntary and the employer should advise the workers that they will suffer no repercussions for not attending or for leaving, and those that do attend aren't going to get rewarded. Ultimately, when you think about workers' statutory rights, everyone should remember it's free and uncoerced communication that is essential to workers' exercise of their rights to engage in union and protected concerted activity. Now, the board, I have argued this before this current board. They have not yet agreed with my position that mandatory captive audience meetings in and of themselves are unlawful. So stay tuned there. But that's one thing that could be done. Another thing that could be done, as many in the webinar know, organizing is just the first step, right? A union is recognized or certified. Unions and employers have a duty to bargain in good faith. The ultimate goal is you want to reach a collective bargaining agreement that's going to inure to the benefit of everyone. And an employer's refusal to bargain with a majority chosen union, right now, the board's current remedy is a prospective bargaining order. So you bargained in bad faith, so bargain in good faith. And oftentimes an employer who gets a board order that says that will then go into the circuit court and appeal it. And, so there's 2-3 years that go by. And then the circuit court says, yeah, the board was right. The employer bargained in bad faith. So guess what? Bargain in good faith. So right now, as far as I'm concerned, there's no real incentive for an employer to recognize and bargain in good faith, because an employer stands to derive great benefits from refusing to recognize the employee's chosen representative, right? The employer gets to defer having to negotiate a collective bargaining agreement with a union that likely will increase current wages and benefits for employees, and the employer benefits from minimizing the effectiveness of the union. And, during this whole time, and frankly, minimizes the effectiveness of the agency, which certified in many cases that particular union. And during the whole time, who suffers? Employees. They don't get the compensation and protections they deserve because the employer refuses to negotiate with their union. And they lose faith in the union and in the government, who hasn't protected their right to bargain collectively. So to me, that's clearly counter to our congressional mandate. And I think that, an employer who has been found to unlawfully violated the statute, they should be forced to make whole employees for the value of the lost opportunity to engage in and make gains in collective bargaining at the time that they should have. And so, you can look at comparator CBAs bargained by high road employers in the same industry and geographic area and similar occupations. It's already been done successfully by other entities. But again, in this particular area, the board has not yet agreed with my position to reconsider the law in this area. So those are two things. I mean, I'm happy to, talk about what the board has done when it comes to bargaining and unilateral changes if I have a minute, but if I don't, I can stop there.
Yeah, I think we're out of minutes. You're amazing. You're going to sign off. I'm going to say one or two things and then give it back to this amazing panel, which will pick up on your great work. We just all want to really send you all the best and keep it up forever and ever and ever.
Thank you. I do want to just say, workers aren't alone. They're strengthening numbers. And I think promoting productive labor management relations is a crucial step towards workplace stability. Workers' voices need to be heard and issues need to be addressed. And thank you all for creating good outcomes and reducing the conflict so that, workers and families and communities and this country can flourish. So take care, everyone. Appreciate it.
Thanks. Be well.
Take care.
And as I flip it back to Sam and this amazing panel, I just want to say that as we look to 2025, the electoral work that many of us will be doing, hopefully a new Congress and therefore the potential for a new labor law. This work of Jennifer and this board should be our starting point. And also this best ever general counsel herself faces confirmation in 1 year. She got confirmed by a 50-50 majority with the vice president breaking the tie. And often these kinds of things, confirming a labor board member, we have one up now, or in this case, the general counsel, slips off our list. And I would just urge everybody here, this is not passive, this meeting. We're going to fight for the best labor law we can. We're also going to fight to confirm these members so that the law can be enforced. Thanks, Sam, and look forward to the rest of the program.
Thank you so much, Larry, and thanks in absentia to General Counsel Abruzzo again for sharing those insights with us. I'm thrilled to introduce the remainder of our speakers real quickly. We're really grateful they're all here with us today. First off is Shay Beckham. Shay is an employee and product specialist at the Apple Store in Short Hills. She's also a leader in her workplace who worked in an attempt to form a union at her work site, and we're really grateful that she'll be sharing some of those experiences with us today. Cindy Estrada leads the Center for Transformative Organizing at the AFL-CIO and is the former vice president of the United Auto Workers Union. And Lynn Reinhart, lucky us, is a senior fellow at EPI, as well as an expert in labor and employment policy, unions, and collective bargaining. She recently served in the Biden administration as senior counselor to both the secretary and acting secretaries of labor, and was previously general counsel of the AFL-CIO. All right. Thank you all for being here today. And I do want to start by turning to you, Shay, and just kind of bring us down to the space of what does all of this mean for workers on the ground? What does this look like for workers on the ground? Could you share with us, why you wanted to form a union at Apple and what the anti-union campaign was like that you experienced there?
Sure. I'm just going to read like a opinion together. Thank you for having me. My name is Shay Beckham. I worked as a product zone specialist at Apple Short Hills in New Jersey for about 2 years. Several months ago, a group of us at Apple formed the organizing committee with the help of the CWA and began the process of forming our union. We genuinely love and like our job. We love serving our opportunity and helping our customers. But working at Apple has gotten harder as our wages have been stagnant and our jobs less secure. After educating ourselves about our rights, our organizing committee reached out to our coworkers about joining together to win a voice our words. A very clear majority signed quickly union cards and signed our public mission statement. Apple knew that the majority of us wanted a union. CWA even wrote to Apple informing them that a majority wanted to be represented by the union and offered to prove this majority to Apple. Rather than recognize our majority in bargaining, Apple decided to do what corporations do. They took the low road. They hired union busters and began to pressure us to vote against our union. I am not a lawyer, and so I will not really talk about any legal issues. Instead, I would like to outline just what happened in my store when we began to organize. Apple held countless anti-union meetings where they would lie about union dues, about strikes, and they would imply that we won't make any improvements through negotiations. In fact, things will actually get worse. Management will show us bargaining proposals from Oklahoma City, Apple, where employees successfully joined CWA, implying that our scheduling would be worse than if we were under a union. They held countless roundtable discussions where they would spread misinformation about unions. They ostracized us union activists, making us feel disloyal for wanting a union. The managers would have walking talks where they would take people out individually to bash the union in private. Some workers were subjected to 10 of these coercive meetings within 1 week. Apple brought in a supposed ex-CWA member who is a part of management at Apple to bash the union about unsubstantiated claims. Of course, this will make it very difficult to question any of their anti-union rhetoric. They didn't want dialogue. They were aiming more for coercion. During election day, they had the same anti-union ex-CWA employee walk the floor of our cells, and although he did no longer work at our location, but he was part of Apple management. One of our main activists who worked at Apple for over 10 years with zero disciplinary actions, was subjected to 4 management investigations within over 1 week bogus, made up issues about his work. A veteran who was denied Veterans Day off for the first time in his work experience at Apple. This message was not subtle. This is a warning from Apple. If you dare cross us, we will go after your job. Apple's campaign of intimidation and coercion was very clear. If you support the union, you will be under their eye and you better be careful. If you're pro-union, publicly, you will be ostracized. And that was very demonstrated and felt by all. All this illegal intimidation works. We lost the election, but no one can call this election free, nor was it fair. Our union has filed unfair labor practices, and we hope the board will recognize that a majority of us wanted the union, but were denied the right by Apple's intimidation, threats, and coercion. Our story is not unique to Apple. This is a war against workers' rights. I know we must keep fighting. We must keep fighting for injustices. This won't be easy, but we must continue to struggle and fight just like our grandfathers and grandmothers did before us. I'm thankful for joining this discussion. I hope our story at Apple will change broken labor laws so workers will one day be able to join unions without having to walk through the fire as we did.
Thank you for sharing that, Shay. That's a very vivid experience, I think, of what it's actually like when you decide to exercise your rights under the NLRA and the kind of opposition you can face from employers, which I'm sure many folks on the call listening in have experienced. Cindy, I wanted to turn to you, actually. What does Shay's experience kind of bring up for you in terms of the challenges workers face when organizing, and how have you seen that play out in other kinds of workplaces?
You know, when I hear the experience that Shay has and all the organizing drives that I've worked on over the years, it's like the saying that my late husband used to say is that you shouldn't have to punch out a democracy when you punch into work. But exactly what happens to non-union workers, but especially when you start to, you know, form your own union, it's basically the boss has you captive and can paint the union as a third party and terrorize workers 24/7 until that election. And so one of the things I want to point out is the work that Jennifer Abruzzo is doing is so important to put the power back in the hands of workers and less influence and interference by employers. But even with all that, right, I think there's two fights. The first fight is in the facility where workers are organizing, where we need those changes to the NLRA to put power back in the hands of workers. But what we're focusing on in the Center for Transformational Organizing is that other fight. It used to be when I organized years ago, you were just fighting the boss. But now you're fighting the whole state infrastructure. We see what's happening in Alabama, Georgia, Tennessee, the southern states, even in the Midwest. And so I think one of the things that's really important is that we build really shared agendas with our community allies. Like the beauty of being small is that we all need each other. And how do we find that way where we're working together, not just to win in this moment where tons of federal investment money is going in for unions, but also before that for the communities that are being impacted. I particularly work in manufacturing, right? We might be happy about a plant, but communities are facing a lot of problems with their water, you know, whether they're going to get the jobs, what's the training. And so I think what we really have to do to beat back against what Shay was explaining is change the NLRB, of course, but then also really build strong partnerships, because that's just our first fight when we see what's happening in these southern states with governors. They're going to fight hard. They run the anti-union campaign for these companies now. And so how do we work together with our community partners, labor, faith, multiple unions, so that we can push back against that, win a community benefits agreement, win a union, but then not stop there like we had in the past. We had one density before, but we didn't really use power. How do we then take that to beat back against the right-wing sort of anti-democratic agenda that we see happening all across the country, whether it has to do with workers organizing or putting children to work or abusing the prison release system. So I think what it brings up for me is just how important it is to build that power on the ground, continue to, you know, make the changes. We have to get the NLRB refunded. We need to get Jennifer reelected, but we also need to not take our eyes off the prize of building strong coalitions that are going to fight together, invest, stay for the long term for the bigger fight in building power.
Thanks for that, Cindy. And Lynn, I want to turn to you. I think we've heard a little bit from both from the General Counsel and also from kind of Cindy and Shay of what the limitations are of the National Labor Relations Act, right? It's like our bedrock labor law, but it also just has these weaknesses when it comes to actually protecting workers. You know, as Cindy pointed out, other kinds of power building are needed. General GC Abruzzo talked about some of the proactive things that the board has done, but could you say a little more about where the board has made progress, even with a pretty, weakened labor law regime?
I'd be happy to. Thank you. as has already been pointed out, we are living in a moment where fortunately we have really the best appointees to the labor agency that we've had in a very long time or ever. Appointed by a president who strongly believes in workers organizing and collective bargaining rights and has followed through on that with the appointments that he's made to this all important agency. But even with that, they are operating under a extremely weak law, which, for example, includes no penalties, no financial penalties for the sort of law breaking that Shay has talked about, and that is all too common in campaigns when workers come together and try to form a union. So there's no monetary penalties. If you violate OSHA, there's a monetary penalty. If you violate workers' organizing rights, there's no monetary penalty. The PRO Act would change that, and we need the PRO Act for sure. But in the meantime, these appointees to the National Labor Relations Board are doing things to try to make the most of the remedies available to workers and to make whole remedies when workers suffer harms, if they face discrimination or other retaliation on the job, that they don't suffer financial loss and they are made whole for those harms. That's just one example of what these appointees to the Labor Board are trying to do. Another thing that they have prioritized is trying to make sure that there's broad coverage of who's protected by the law and what sorts of activities are protected by the law. So, for example, this NLRB issued a decision to tighten up on the definition of independent contractor. So employers can't misclassify workers as independent contractors and deprive them of their labor law rights. So under that ruling, more workers are eligible for protection under our labor law. And more activities are protected under our labor law, under the interpretations of this NLRB. That's super important. And the last thing I'd like to mention is, in addition to the CEMEX decision that General Counsel Abruzzo described, and I do want to also underscore her suggestion that people read her memo, because it's a very good roadmap to understanding that decision and how to actually implement it in the field. Simultaneously with not simultaneously, but roughly at the same time of the CEMEX ruling, the NLRB also issued new rules to try to streamline the process when workers file petitions and want to get elections on forming and joining unions. And those rules have dropped the time from election petition to election by about half, which is huge. So you put that together with the CEMEX decision and trying to facilitate the process, crack down on employer law breaking during the election process. And it really adds up to real change that is being made by these appointees. And I think it's on all of us to make the most of this moment and to make the most of this change and make sure people know about it so that workers can take action, which we know they want to do, and take advantage of really an agency that truly has their back when they want to exercise their rights to organize.
Thanks for that, Lynn. Cindy, I want to come back to you. You got into talking about this a little bit already in terms of community partnerships and really prioritizing organizing on the ground. Could you say a little about what that looks like in terms of the mission of the Center for Transformational Organizing, and what opportunities you see coming up with the landscape the board has set up and kind of the policy landscape you mentioned? Like, what does that actually look like in terms of workers building the power for workers to be able to organize and take advantage of these actions by the board and these interpretations?
Yeah, so, part of our theory of change is that in order for workers to win at scale, right? Because we've won before, we've won numbers only to see those numbers flip and change, but to really win at scale in a sector and a density, or, and win strong first contracts, you really have to have sectoral density. And that's going to require unions to invest long-term, organizing, not sort of jump in somewhere it's not there and jump out, but really build with those workers and coordinated strategies, shared resources, really building lasting infrastructure in industries and geographies, and then building that power, as I said, with deep alignment with the community. Someone said in the chat, bargaining for the common good. That's exactly what it is, but it's organizing, sort of uniting for the common good, so that we're making sure that when these new investments, so some of these investments aren't going to come in until 27, 28, they're getting put off. We have all this time in some of these states to really build those shared agendas so that we're fighting for community. So for example, Tennessee for All in Tennessee is, trying to get a community benefits agreement around the Blue Oval investment in Tennessee. You got a number of companies that are getting, tons of money. And part of the DOE has done a great job in, really requiring community benefit plans. We want agreements, right? So that means how do we work with that community to identify their issues long before this plant set up, so that we together in labor, right, are fighting, really showing that labor and community, a worker and a community member are one and the same. So how do we do that on the front end, and making sure that anything that's happening around, one place, for example, you're finding in new sites, rent's going up. One place I went to, everyone got a letter in the mail, rent was increasing by $400 just because of that investment. So you could imagine community is not that excited. How do we fight with them to change that, to make sure that they have livable housing, they have a good, good education system? So really working around those community benefits to start to work together on what it means to build power together. But like I said, not end there. So it's taking that federal investment money, working with our community partners to make sure there's community benefit agreements that address community needs. And then those same community members, they'll be with us to fight when the company starts to run their campaign, or if we keep having good NLRB councils like General Abruzzo, maybe we have better labor law, but we're still going to have to take that attack from the outside by those governors and sort of everyone else who thinks that if workers get power, their jobs are in jeopardy. And they are, if we do this right, right? We want to make sure that we have a democracy over the next decade as we get tons of investment. So it really isn't, and that's a lot of work, right? That doesn't necessarily turn into numbers overnight, but if you get the power, the infrastructure, and the capacity, we'll get the numbers. I feel like we've never gotten the numbers because we didn't make that investment, because everyone wants quick numbers, but to get there, it really takes working together and strategizing, sharing resources, investing, and working with our community partners in, I think, a deeper alignment than a pay to play, where we're just calling in my days in organizing, we wanted help. We asked a community member to send a letter. It's like, no more of that. Like, how do we really build this deep alignment and shared agenda? So I hope that explains it a little, but it's going to take time to build, and it's going to take a willingness to do what it's going to take if we really want to build power and save our democracy.
Absolutely. And I think it's especially powerful to think of the impact of that kind of situation, like for folks like Shay and the coworkers that she was organizing, to have community support, what that difference might have made in that campaign. Lynn, I want to turn to you. This is hopefully maybe also addressing some of the Q&A that we're seeing coming in. We'll turn to Q&A shortly, folks. So if you haven't asked your question yet, please do go ahead and put it in the chat box. But so we know there are big implications coming up this year and next year for what happens at the board. There's the renomination of a member and a confirmation coming up now. There's GC Abruzzo next year. And then, of course, just longstanding attacks that we have seen mostly from the right on the board's authority and their funding. There's appropriations conversations coming up this summer. The board has been in a long time problem with understaffing. I think some folks have asked a couple questions in the chat, and I'm sure folks are aware of how protecting these rights is often only as good as the board's ability to enforce it. And when they've been chronically understaffed and underfunded for so long, that's really difficult. So Lynn, can you just explain a little why these kind of legislative wonky or political flashpoints actually matter for workers?
Excuse me, absolutely. And I think something that's important to keep in mind is when you talk about the National Labor Relations Board, it is actually an independent agency. It is not an agency like the Department of Labor or the Department of Energy that is really under the president's direction and control. It's an independent agency. So what can an administration do? An administration has the authority to make appointments to that agency, and the administration can also advocate for a strong budget for the agency. And there's an unbelievable contrast between this administration and the prior administration, and what we are looking at for a future administration in terms of who was chosen to be on the NLRB to protect workers' rights. And I just want to underscore, General Abruzzo was exactly right, that this law is not neutral about worker organizing. This law was passed to support and promote worker organizing. But the prior administration put people on the National Labor Relations Board who had been corporate lawyers and had no experience promoting workers' rights. In fact, they took the law in the opposite direction and issued decisions that gave more power to employers and less rights to workers. We did a report at the Economic Policy Institute that showed that the Chamber of Commerce was 10 for 10 in getting its wish list for actions by the prior administration's NLRB. And fortunately, this group of appointees has made great progress in undoing that damage and also taking some other steps to advance workers' rights, which is what this law is supposed to be all about. But it really matters who's making the appointments and who the president puts on the National Labor Relations Board. And right now we have, President Biden fired Peter Robb the first day, a minute after he got sworn in as president, appointed Jennifer Abruzzo, who we've just heard from, appointed experienced workers' rights advocates to the NLRB, including the first Black woman to ever serve on the NLRB. And that's really significant. And I think people need to pay attention to these nominations and make sure that the right person is making the appointments and those appointees get through. And then secondly, with the budget, the National Labor Relations Board, it has been chronically underfunded, as you pointed out. It's an agency that has an annual budget of about $300 million to protect the organizing and bargaining rights of 100 million workers. That's a big job with not much money. And the agency has lost staff because of the flat funding. They're trying to build it back up, but they're understaffed. And what that translates into is delay in the region when cases are being processed, when petitions are being filed, when workers need help if they're facing retaliation when they organize. And under this law, it's all on the National Labor Relations Board. Workers do not have the right to bring a case forward on their own. They are dependent on the National Labor Relations Board and on Jennifer Abruzzo and her team to bring their case for them. So if the agency doesn't have the money and they don't have the people, workers' rights really suffer. So I think it's on all of us to really pay attention to the budget situation and make sure that this agency gets some more money, because workers want unions and they're filing petitions. They're up 35%. And we know from what we're seeing on the ground, workers want unions and they need this agency, and they need a fully funded, robust agency there protecting their rights.
Thanks for that, Lynn. And Shay, I want to turn to you before we open it up to the other Q&A. Having gone through the experience that you did, experiencing such intense opposition, and union busting from Apple, what would you want other workers who are thinking about organizing a union on the call to know about your experience? What would you want them to take away from this, or things that you wish you would have known at the time?
I want them to know, to keep the fight going. Change is never easy in the infrastructure of our society, American society, especially when it comes to rights and bargaining. That was never easy. It was very tumultuous. It was a tumultuous road ahead. And so if you are trying to organize, or you're trying to fight for your rights as a worker, keep the fight.
Perfectly said. Okay, we have a lot of questions coming in, so I'll try to direct them to maybe a specific person or to anybody who wants to take the first one. We have a question here. I'm wondering if folks could speak to some of the challenges faced by workers, specifically in the American South. We got some questions in about bills that have passed recently, like in Georgia, that would essentially punish companies that choose, even voluntarily, to recognize a union. And Cindy alluded earlier to governors and other policymakers in other places really being huge obstacles to workers here. Anybody want to speak to kind of the specific challenges for workers in the South briefly?
I mean, I know Lynn can speak to this too, but just, on the ground and the work that, we're doing in Georgia and Tennessee and other places, it's, as everyone knows, it's really difficult, but I'm going to go back to that, why we need to build that infrastructure and capacity, because we're not going to beat against that unless we do that kind of building and working together with our allies in a really collaborative, shared way. But, I'll give you an example. In Tennessee, this is a very Republican state. And because they have a coalition of 27 groups around the table, the governor's, signature bill was vouchers for the whole state, right? And by them working together in a statewide table, they were able to go into rural counties all together, working together, unions, labor, faith leaders, and push back against this voucher bill. And they won. And that, normally you're not winning statewide issues in Tennessee, but because they built that coalition and because they all decided to take on that fight, and they went into those communities with their organizers and shared that agenda, they beat back the governor's voucher program. And so to me, that's how we beat back against what's happening to workers in the South. And also talking about, race from the beginning, because that's what, employers do well and these governors do well, is learning that they divide us by shift, by classification, but by ethnicity, by gender. And so having that conversation on the front end to help workers see, what it is that they have in common, and how race it affects everyone, and when they use that as a way to divide. So it's going to take a lot of work. And these aren't easy places or safe places to organize. So I think to Shay's point, we just have to continue that fight. But communities are only going to trust us in labor if we stay vested and stay for the long haul, so that we can let them know that we ain't going away when we don't win a campaign or when we don't win an issue fight. And so I think that's going to be critical to winning the South, working together with our immigrant rights groups. I saw Yanira's on the call. I mean, the work that we've done in the Department of Labor in terms of helping get protected status for immigrant workers, like how do we get that out there, right? Because that's the first group of workers that they're going to try and target to divide and to scare. And so how is it that we really build that multiracial coalition for the long haul?
I want to just jump in and say 100% to everything that Cindy said, and nobody could say it better than that. And to add just one thing, which is, let's be real, that a lot of the purpose for these fights is to drain attention and resources away from the labor movement, so that they have to spend money fighting these fights as opposed to working with workers and who want to organize unions. So that's just part of what's going on. And they're doing that to us in the workers' rights community. And they're also doing it to the National Labor Relations Board. We've seen these huge companies, SpaceX and others, attacking the constitutionality of the National Labor Relations Board, which is, there's settled law that the NLRB is constitutional, and these challenges should be rejected as absolutely spurious, but the NLRB has to defend them, and it drains resources away from this agency that doesn't have any money or to begin with. And that's part of the point. And I just think we need to name it, that that's part of the game here, and that we need to, together with our strong alliances, to fight back against it.
And just a reminder, we are winning in the South, right? You had Volkswagen, you have Bluebird, who, 1,000 workers there, mostly Black and brown workers. They won and they got a contract. So that's exciting. We have New Flyer, who also community benefits agreement and a union with CWA. So steelworkers, CWA, and UAW. That's exciting. That means it's possible. And we just got to keep doing it. So I just wanted to point out those, because I don't want everyone to think it's doom and gloom. We are winning in the South. Unions are winning.
Thanks for that. I think this next question is another one maybe that I think is interesting about the nitty gritty of what it's like for workers. So maybe this is for Shay and for Lynn. There's a question asked about what can be done, or is anything being done to bring the NLRA into the 21st century? And the question there was specifically about the experience of electronic voting, electronic filing for an election. So I don't know, Shay, if you want to speak about what that was like, kind of in terms of maybe a laborious process on your all's side when you were organizing, or Lynn, if you have thoughts, would love to hear.
Yeah, we were quite surprised on election day that we're still with the paper and pen, especially for us to be tech companies. If we can improve that, I think that can also bring more confidence in voters' privacy.
Yes, 100%. Unfortunately, Republicans in Congress have put a rider on the NLRB's appropriations for the past, 10 years, maybe-ish, prohibiting the NLRB from doing electronic voting. So they're prohibited by Congress from bringing the voting system for our private sector labor law into the 21st century, even though that's the way of the world. It's the way other agencies run elections, and they've worked very successfully. So yes, it's a great question, and there's a lot of work that needs to be done to strengthen and update this law. Fortunately, Larry Cohen is not going to rest until that happens and we get the PRO Act passed. And hopefully getting rid of that rider on electronic voting could be another piece of this reform so that this law can be modernized and actually operate in the century that we're in.
Absolutely. There was another question asked about how we, the workers, everyone on the call, can help secure a better budget for the NLRB, which might also kind of tie into questions about how everybody here can lift up what work the NLRB is doing and how it's important. Anybody want to take that? What the typical person can do?
I think we should turn that over to Larry, but maybe.
Okay, I would just say one quick thing on it, which is it's a political decision. So when we're active politically, we need to follow up, as Lynn said, and we had a huge fight on this last year, which ends up being a negotiation because of the House would like to eliminate, the House leadership, Republican Speaker would like to eliminate the National Labor Relations Act. It's now part of the platform of the Republican Party to eliminate it. So this is all about why electoral work matters. But we can't just rest on one party versus the other. It's a question of making it a real priority, because without that funding, as Lynn has said at least twice now, it's great to have CEMEX and other things, but the clock kills us. They run out the clock. They use up the minutes. So it's like a basketball game if we're watching the NBA, women's NBA, and we never get on the court.
That's a great flag. And I'll just, oh, sorry, go ahead, Lynn.
Yeah, I'd just like to add what Larry said, that, more visibility to these issues would be really helpful. And people speaking out about it and sharing their stories like Shay just did here, and getting those stories more into the public eye, that workers want to form unions and they are being held back by a weak law and by weak funding that's hampering an agency that really is trying to do the right thing by working people. And I think just by bringing some more visibility to these stories and making it more part of the public discourse, as well as, making sure elected representatives know about that, would all be to the good, and is something that we can all do.
And if I could just add, like, to Lynn's point, it's like, having been an organizer for a number of years, sometimes we get so used to what these companies do, we're not as outraged as we were when we first started. And I think we're getting that outrage back. Like, this is horrendous what workers have to go through. We're so used to losing in the NLRB, we're winning now in some cases. So to Lynn's point, the stories and our anger behind it, right? That workers should not have to go through this because they simply want democracy in their workplace. And we wouldn't have that in any other place except in the United States, in a workplace when workers are trying to form a union. So for me, it's like, really, even with our leaders who've been around, remind them how outraged we were when we first started, right? And just because we've had to deal with it so long doesn't mean that outrage should go away. I think it needs to come back, and we need to challenge these companies every time we hear a worker going through what Shay had to go through to try to form a union.
Absolutely. I think we are very close to time, unfortunately, so we're going to have to wrap it up here. I did want to maybe smush together a couple of the questions. There's a couple folks on the Q&A who mentioned that they are organizers in training, or first-time organizers, or thinking about starting a union in their workplace, and kind of wondering where to start. And I know Shay had a great message for folks at the end of the panel section, but in lieu of closing remarks, want to see if Lynn, Cindy, and Shay, if you have anything to say for folks on where they might want to start in terms of learning how to best take advantage of some of these actions at the NLRB, and then we'll close it out.
Well, I'll just start. It does start to talk with, starting to talk with your coworkers and really identifying, one is the coworkers who are suffering issues in their facility, but it's really starting to take a step back and really start to think, who are the respected workers in that workplace that other people look to? And maybe you can't talk to some of them yet because they're not there, but to start to think through, so what is that natural system of communication that's happening in your facility, and start to map that out, because that's what the company's doing. they're learning who knows who talks to who's respected, who do people go to. And I think taking a step back and thinking about that yourself is a first step.
In terms of resources, I'd like to just point to three, but there are lots. One is, especially on social media, another of the initiatives that General Counsel Abruzzo and her team have undertaken, which is fantastic, is initiatives to make sure workers better know their rights under the law. And they've done a whole series of fact sheets and slides and know your rights palm cards and things like that that are all on the internet, Twitter, Facebook, Instagram, downloadable. And they're really good resources and a roadmap for workers who are interested in learning more about and exercising their rights. The AFL-CIO has good material on its website about how to go about forming a union and contacting organizers for additional assistance. And then the last thing, I can't help but say that the Department of Labor has set up the Worker Organizing Resource and Knowledge Center, workcenter.gov, which is it's a website that's got tons of resources on unions, the union advantage, and how to form and join a union. So those are three resources that are available to folks that I think provide a lot of really good information.
And just from the ground floor, I would say find people who are respected disruptors, people who advocate for the masses. They're there.
Perfect note to end. I want to thank you all for being with us today. Lynn, Cindy, and Shay for your time, and Larry as well. Just as a reminder, we will be sending around a recording as well as the links to many of the resources that were mentioned on the call or that folks who were speaking on the call have authored. And I did just want to say, if you're watching on the live stream and weren't able to register for the webinar, if you're not already subscribed to EPI News and you want to make sure that you get that update, just go to epi.org and you'll be added to our mailing list if you sign up there, so you can get this and future updates about other events we're doing. I so wish we had more time for Q&A. This was a great conversation. And thank you all for joining, and hope you have a great afternoon.
Solidarity.
Solidarity forever. Thanks, Larry. Bye all.
Betty.